You are Francisco Salto.
Yes, sir.
Mr. Salto, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent.
What happens when a night out at the bar turns into a criminal confession? When Walmart catches you red-handed? Or when you blow twice the legal limit with no license? Today we're diving into a wild day in Texas court where theft, DWIs, and bond violations collide. You'll witness a judge who takes no-nonsense, defendants making shocking admissions, and legal consequences that'll make you think twice about breaking the law. From stolen purses to high-speed drunk driving, this is real justice in action. Let's jump into Harris County Court and see how these cases unfold.
Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On December 20th, 2022, officers responded to a theft call. The complainant stated she was inside Eagle Hall, a bar in Harris County, Texas, when she noticed someone had stolen her purse with approximately $130. The complainant has pointed out a male who was sitting next to her when the money was taken. The defendant later admitted the offense to the officer and that he took approximately $140 from the complainant's purse.
How did they see who saw him?
There was no allegation that he was necessarily seen taking the money. From what I understand, Your Honor, the pleading witness was sitting next to the defendant. She noticed the money was missing. Officers arrived, asked the defendant about it, and the defendant admitted to taking money.
Got it. Okay. Mr. Salto, I'm going to find that there's sufficient probable cause to go forward with the case. I am ordering you now as a condition of your bond not to go back to this bar. Do you understand?
Yes, sir.
You're also ordered not to have any contact with the complaining witness in this case. If I find that you pick up a new case, if I find that you violate any of these conditions, I will lock you up and I'm going to make your bond extremely high. Do you understand?
Yes, sir.
I guess, I'm going to order you not to go to any bar. You're ordered not to go to any bar. You understand?
Hold up. Did you catch that escalation? The judge just went from don't go back to that bar to don't go to any bar. That's a massive restriction on someone's social life. Francisco admitted to stealing $140 from a woman's purse. And here's the kicker. He wasn't even caught in the act. He straight up confessed when the cops asked him about it. Talk about self-incrimination. Now he's facing 6 months in jail, a $2,000 fine, and a complete bar ban. Was a confession worth it? Let me know in the comments. Would you have kept quiet or come clean like Francisco did?
Understand? You have the ability to hire lawyers, sir. Do you have the ability to hire a lawyer?
No, sir.
Okay, I'll have you fill out an application. We'll look to see whether you qualify for a court-appointed lawyer. For a court-appointed lawyer, I need to know everything about you, whether you work, how much money you make a month, how much money you have in the bank, what kind of car you drive, and then we'll look to see whether you qualify. Deputy Etchigoin is going to give you one. We'll have you sign a receipt, and then I'm going to have you take a seat in the jury box. Do not leave until you sign the bond conditions, sir.
Go ahead and sign, please.
So no going to any bar,
Yes, Your Honor.
no going to this one, especially, no contact with the complaining witness, no new cases.
Judge, that's the only one for now. The other one has an attorney that's not here yet.
What's the last name?
Gonzalez. On page 7.
Got it. Any THAs?
No, Judge.
Counsel, you ready?
Yes, sir.
Come on up.
Hey, how are you today?
Pretty good, you?
Just quickly wanted to do a motion to substitute
Okay.
on a case and I have it there for you.
I'll put it in here, so I'm trying.
Got it. There, yeah. Is it on docket today?
Miguel Castillo is on the docket today, Your Honor.
Senator Lopez, Judge, on page 12.
Is it an old case, Dave?
Brand new.
Got it. Okay. I don't have it yet, but I'll sign it when I get it, and then you guys are good to go.
Your Honor, I'm Attorney Reese from Pearland, and this is my law clerk. He
Nice to
just
meet you.
took the bar and graduated law school.
Nice. Congratulations. Treat it well. It'll treat you even better, I swear. This is such a great profession. You'll learn like crazy, and then the sky's the limit, man. If you treat it well, it'll pay back tenfold. Really.
We're excited to join you.
Yeah.
Thank you, Your
Okay,
Honor.
guys, for sure. Take care.
Judge, can I give you a call?
Yeah.
It's, let me know when you're ready.
I'm ready.
2535
Okay.
924 for Great House. So I see on Friday that he signed a no driving affidavit and then an amended order was made from the pretrial officer in here that day for Scram. So I'm assuming in the amended order, you also wanted no driving.
Correct.
So I will have to make an amended order on that.
Yeah,
Because
just
it
waive
wasn't
it.
there. However, the case manager reached out to me and said that he believes the client was driving yesterday because his ignition interlock reported him driving and there was a roll and retest. So leading him to believe he was doing that. But we will not be able to submit a bond violation due to that box for no driving in our conditions, pretrial conditions.
I
being
ordered him on
selected.
that day not to
Yes.
drive.
Yes, and
So
so
he
the no
knew not to
driving,
drive.
yes, he knows not to drive, because of the no driving affidavit, but that's why they reached out, because they said, hey,
So
And
can
our
you get
conditions are okay.
pictures of him starting the car?
I can get the report.
Right. I want you to file a BVR.
You'd like to file?
Yes,
Okay.
file a BVR.
Let me
And I'm gonna
reach
set
out.
it and then we're gonna provide pictures to counsel and then we'll have a hearing on
Yes,
it
Judge.
on Monday.
This is where technology becomes a defendant's worst enemy. The ignition interlock device just snitched on this guy. It recorded him driving when he signed an NO driving affidavit. For those who don't know, an ignition interlock is basically a breathalyzer for your car that you have to blow into before it starts. But here's the catch. It also tracks when you use it. This defendant thought he could sneak in some driving time, but the device logged everything, including retests while driving. Now the judge wants photographic evidence and is filing a bond violation report. The lesson? When the court says don't drive, they have ways to verify if you're following orders.
On Monday.
Today as well, Judge.
Driving today?
Yes, Judge.
Okay, I'm ready.
Yeah, if you can file the BVR today, please.
Yes.
Hi, coming up. Good morning.
Nabiyama. It's an off docket matter. The cause number is 254-3073.
Okay.
Okay.
I wanted to approach about his bond conditions. He was ordered to get an interlock device. However, he was incarcerated from January up until last week. But while he was incarcerated, his brother actually wrecked his car, so he no longer has the car, so he's not driving. His license is also suspended, so we wanted to see if we could get it changed over to a portable.
Okay, but I need him here to sign an affidavit.
He's
Be
here.
here?
Yes, sir.
Okay, so we'll need him to sign an affidavit. Come up. Good morning, Mr. Nabiyama. I am ordering you not to drive. Do not drive. I don't care what is going on in your life. I don't care what you need to do. I don't care if you have to go to the hospital. If you do not have a license, if you do not have insurance in your name, and especially an interlock in your car, you're not allowed to drive. It's really going to go poorly for you if you do. Do you understand? I'm going to have you sign an affidavit with me today promising you're not going to drive. This is a court order. So if you do, and I find that you do, I can have a contempt hearing. Do you understand? Okay, so we'll have you sign it. And then now what we'll do is we'll give you a portable device that you're going to take with you wherever you go. I'm going to pay for it so that there are no issues. Okay? Okay, thanks, guys.
Yeah.
Okay. Hi,
Morning, Mayor French.
please.
Approaching off docket on Mr. Escanilla. I sent an email last night on that one. Do you need a clause number?
No, I got it right.
Okay.
Do you need a cause number?
I do.
It's 239-0060.
Sorry, I didn't even think about offering it to you. My apologies.
Sure. So we're here because they filed a bond violation report. He was ordered to submit to a drug and alcohol test. He tested positive for marijuana.
Yes, Judge, that was on the 14th. He appeared in court on the 14th. That's the day I got appointed. You sent him for a drug test that day. According to my notes, he came back positive that day. He and I approached you, and on my notes from the 14th, it says he did test positive, but you were going to give him 50 days to get clean. So I got a test date for him for May 6th, but my next appearance date is sometime in April for him, and I think he has to be here then too.
Okay.
So, but he's set for the 4th. Can we withdraw that setting and just keep how it was, please?
For sure.
Thank you so much. It's just a record snafu. Thank you so much, Judge. May I be excused? That's all I had today. Thank you.
Now, this is what good legal representation looks like. The attorney just saved their client from a bond violation hearing by pulling out detailed notes, showing the judge had already given his defendant 50 days to get clean after testing positive for marijuana. Without those notes, this guy would have been facing jail time today. The prosecutor filed a violation, but the defense attorney had the receipts, proving the importance of documentation in court. Remember, folks, a good lawyer doesn't just show up. They come prepared with evidence that can be the difference between freedom and incarceration. This defendant dodged a major bullet, thanks to his attorney's diligence.
Thank you.
Okay. I'm ready when you are.
All right, Judge, next is page 3. Davis, come on up. Danielle?
Yeah. You said number 3?
Page 3. Davis.
You are Danielle Davis. Davis, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On March 31st, 2025, in Harris County, Texas, a law enforcement officer was dispatched to a theft call at Walmart and made contact with the loss prevention officer who had detained the defendant. The loss prevention officer said he witnessed the defendant concealing items in a bag and then proceed to pay for several items, but not those concealed in the bag. The defendant then passed all points of sale without trying to pay for the concealed items. The total value of the concealed items was $264.78.
All right, Ms. Davis, I'm going to find that there's sufficient probable cause to go forward with the case. I'm warning you now as a condition of your bond not to go to Walmart, any Walmart for any reason. Do you understand? If I find that you do, I will revoke your bond, put you in jail. No more PR bonds, ma'am. Do you mind filing those conditions, please?
Yes, sir.
Ms. Davis, do you have the ability to hire a lawyer?
No.
I'll have you fill out an application for a court-appointed lawyer. I'll take a look to see whether you qualify. I need to know everything about you. Don't just put zeros because I'm going to send it right back to you. I need to know how much money you have in the bank, what kind of job, what kind of car, all that jazz, and then we'll take a look to see whether you qualify. Deputy Miranda's going to give you the application. I'll have you sign a reset with Victoria, and then we'll have you take a seat in the jury box, man.
Classic Walmart shoplifting case. But here's what makes it interesting. Danielle tried the old pay for some items while concealing others' trick. Loss prevention was watching the entire time. She concealed $264.78 worth of merchandise, paid for some items to look legitimate, then walked right past all the registers. Now she's banned from every Walmart, not just the one she stole from. That's a serious inconvenience in today's world. The judge is clearly fed up with repeat offenders, warning her there'll be no more personal recognizance bonds if she violates. For those wondering, a PR bond means you're released without paying bail, lose that privilege, and you're sitting in jail until trial.
Yeah.
All right, page 7. Gonzalez, come on up.
Morning, Judge.
Hey, Eric, how are you, man?
Right, I don't know, but I don't want to not put nothing, you know.
Yeah, I mean, I just know.
I just look at and don't. So I said.
Okay, I'm just.
Yeah.
She just puts all that on everything?
Looking for a job in the.
I get it. How do you eat them? You have to have money to eat. How are you eating?
Yeah.
You got some? Okay, that's good. Yeah, Social Security's good. That's okay. Yeah, that's fine. As long as you put down something, so we know that you have some income coming in, right? Okay. You are Ricardo Gonzalez. Mr. Gonzalez, you're charged with driving while intoxicated. It's elevated to a Class A misdemeanor because of the high blow. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir. Okay.
On March 27, 2025, in Harris County, Texas, a law enforcement officer observed a vehicle traveling 90 miles an hour in a 60-mile-an-hour zone and failed to signal a lane change. A traffic stop was initiated, and upon contact with the defendant, the law enforcement officer observed a strong odor of alcoholic beverage, slurred speech, and red bloodshot eyes. The defendant admitted to consuming 10 beers. STs were conducted at a nearby parking lot where the officer observed 6 out of 6 on the HGN, 2 out of 8 on the walk and turn, and 1 out of 4 on the one leg stand. The defendant consented to a breath specimen in blue 0.16 and 0.158.
This is why you never admit to drinking when pulled over. Ricardo told the officer he had 10 beers and then blew twice the legal limit, 0.16 and 0.158. The legal limit is 0.08. Folks, he was going 90 in a 60, failed to signal, and bombed every field sobriety test. But here's the kicker. He doesn't even have a driver's license. This transformed a regular DWI into a Class A misdemeanor with up to a year in jail and $4,000 in fines. Between the admission, the failed test, and the lack of license, Ricardo handed prosecutors a slam dunk case on a silver platter. Remember, you have the right to remain silent for a reason.
Mr. Gonzalez, I'm going to find that there's sufficient probable cause to go forward with your case. You look up, see, is any prior DWIs and a license, please?
I do not see any prior DWIs, Your Honor. However, I'm unable to look up his driver's license because there is a driver's license number that we have in our system. From what I have, I'm not sure if that means he does not have a driver's license.
He does not have a license at the moment.
You're not allowed to drive. I don't care what is going on in your life. I don't care that you need groceries. I don't care that there's a kitten that has to go to the hospital. You will be signing an affidavit with me today promising me you're not going to. If I find that you do, I can have a contempt hearing. You can be facing an additional 6 months in jail and a $500 fine every time you drive. I don't know what your immigration status, but if you're not in this country with permission and you go to jail and immigration finds you, they will put a detainer and you'll be stuck like Chuck in there until this case is over, and then you get shipped off to immigration. Do you understand? Part of your other bond conditions are that you're not to consume alcohol or illegal drugs or unprescribed controlled medication. I'm going to randomly test you. If I find that you're using, likewise, you will go to jail. No more PR bonds for you. Now, you have a lawyer. Because you have a lawyer, I will waive your appearance, but it is your responsibility to stay in touch with Mr. Benavides, and he will tell you when you have to come back to court. If he tells me he can't get a hold of you because you're playing games and you're not responding to phone calls or text messages, likewise, I will issue a warrant for your arrest. For now, we'll have you come up here, swear a test that you're not going to drive. You'll get to Victoria to sign a reset. We'll fleece you for your bond conditions, and then you're free to go. Thanks, sir. Okay, I gotta run.
Okay.
So we're not late.
This one is your qualifications, that's the no drugs and alcohol, random drug
Guys, I gotta run. I'll see you guys tomorrow, though. We'll be bright and early.
What a day in Harris County Court. We witnessed Francisco's $140 bar theft confession, leading to a complete bar ban. High-tech ignition interlock devices catching bond violators red-handed, and Ricardo's catastrophic DWI case where he admitted to 10 beers and blew double the legal limit with no license. The judge showed zero tolerance, threatening contempt charges, immigration consequences, and jail time for any violations. These cases prove that honesty isn't always the best policy in criminal court. Technology is making it harder to violate bond conditions, and judges are cracking down hard on repeat offenders. The lesson? Know your rights, get a good lawyer, and think twice before breaking the law. If you found this courtroom breakdown as jaw-dropping as we did, smash that like button. Drop a comment about which case shocked you the most, and subscribe for more incredible real-life courtroom drama. Hit the notification bell so you never miss our next legal breakdown. Until next time, stay out of trouble, and we'll see you in court as observers, not defendants.